Hi, my name is Mark DALY, and I'm an immigration attorney. And this video tutorial is dedicated to criminal convictions and issues regarding bad moral character that can prevent you from getting your green card when you are trying to adjust your status based on marriage to a U.S. citizen. This video tutorial can only do so much. What we're talking about is a very, very complicated part of the law. And my intention, though, is to discuss some of the issues, discuss some of the law, show you what's out there, and help you think in an organized way around a problem that you may have had in the past that is popping up for you because you're filling out some of these forms and wondering, I wonder if I should put that down on the form, or what's going to happen if I put that down on the form. It's very, very important that we fill these forms out truthfully and are honest with the immigration service. And at the same time, there are very real distinctions between criminal law and immigration law that are not clear. And yet you're being asked to present information that is very significant, very important information, has a huge impact on your life. And so my goal is to give you an overview of the immigration law as it talks about what they call inadmissibility or excludability. When you are adjusting your status, getting your green card, even if you've already come into the United States, you're actually requesting to be admitted as a permanent resident. And the word admission then is very specific to being allowed to come into the United States formally, to be formally processed. So, if you came in as a tourist, you were admitted as a tourist. But now if you're going to get a green card, you have to be readmitted for permanent residency. So admission then is the process that you're going to go through to get your green card. So when it talks about grounds of inadmissibility, what that means is that inadmissible, unable to be admitted, there are certain things, certain grounds, certain issues that if you've done them or they pop up on your record, you're not going to be able to be admitted. You are unadmissible or inadmissible. Anti-admissible. The language is important, but I want to give you some sense about what we're talking about here, because I'm going to take you through the actual law. I'm going to show you the grounds of inadmissibility as they're written in the statutes. The laws are written for people to read, and I want you to read them. I want to actually show them to you and walk you through those laws so that you really get what's going on. And that way, when you go to work with an immigration attorney, you'll have some knowledge about your situation, and you'll understand, and you'll be so much better able to produce a good result with an immigration attorney if you know some of the basic concepts around what you've done and what it means. Now, I really enjoy the practice of immigration law as it pertains to basis of inadmissibility, because my personal belief is that people deserve a second chance. I know I have done some stupid things in my life, and I have been given a second chance. I've been given many second chances actually to get back on track. And growing up as a teenager, I actually fell on the wrong side of the law a couple times, and I went to juvenile hall over the weekend, and I had to tell the state bar when I passed the bar, I had to tell them about my criminal convictions, even if it was a juvenile, and even though the cases were closed, And I thought about that. I thought, you know, I got to fill out this application to be a lawyer, and they're saying list all the criminal convictions. And you know, this was when I was a juvenile. This is when I was 16 years old. You know, do I have to put that down? And I thought, you know what, I got to lay it all out. If they don't want to take me because of the stupid things that I did, then that's my karma. You know, that's what I get. I'm just going to go for it. And of course they let me in because it's, I don't know, it's, you know, it's really, in the big picture, society wants people to participate at a high level, and a lot of times giving people a second chance, they come out so much stronger from those experiences. So I know that was really my case, that when I got through my teenage rebellion, I was focused afterwards, and I just said, you know what, I'm not going down that road again. So I came out to be a better person. And so so the issues of crimes and the issues of inadmissibility, they do ring for me. And so I really I enjoy and I take very seriously my time when I'm working with my immigration clients, and we're going through their rap sheets or the stuff that they've done, and you know, we take it apart. We find, okay, what happened? What were you convicted of? What were you charged with? What were you arrested for? What did you say happened? All these different aspects of a incident, you know. And a lot of times we're able to get waivers and we're able to get relief for people, and sometimes we're not. And but it really, in my experience, I have met so many incredible people who have done stupid things in the past. So and anyway, that's my story about this. I want to show you some of the materials that I use. There's a guy, Norton Tooby, who's in California. This book is the Crimes of Moral Turpitude book. An amazing, amazing lawyer. Very inspirational, awesome lawyer. Here's his book called Aggravated Felonies here. Look at that thing. Some of the things that I like to use. Also, it just shows you, like, this is deep. I mean, I use these books and I dig into these books because when you're analyzing an incident that happened in the past, there's a lot of different things going on you have to be aware of. And so some lawyers have completely devoted their whole practice into this niche of criminal incidents and bad moral character issues. Because some of the stuff you can get, are grounds of inadmissibility, don't even have to be crimes, don't even have to be convictions. Some of the stuff, and you'll see on that I-485 form, they ask you, have you ever just knowingly committed, even without being arrested, of a crime or bad moral character, acts of bad moral character or acts of moral turpitude. Here's another one. This one's the National Lawyers Guild, Immigration Law and Crimes. Look at this one here. These books are very valuable. They're expensive, and they weigh a lot. Here's Immigration Law and Defense, the two National Lawyers Guild books that I also like to use. And then there's the whole online database. So, and this is the immigration side. There's also the criminal law side. And here's the key, is that the criminal statutes are state specific. So the Tennessee criminal statutes are completely different from the California criminal statutes. So if a crime is committed in Tennessee, it's going to be completely different from a crime that was committed in California as it relates to immigration issues. So, a drug crime in Tennessee might be completely different, have a completely different effect than, the same drug crime if it was committed in California, because the records of conviction are going to be different, and the facts that you're looking at are going to be different, and the law that was applied are going to be different. So for that reason, the other thing we do is we go into, state statutes and do research on state statutes. But we, the thing is that we most often work with state licensed criminal attorneys who know the state criminal law to understand the nuances of the state law, because like I am licensed in California, so I'm licensed to practice law in California, but here in Tennessee I have great relationships with Tennessee criminal attorneys who can coach me and advise me on the way that different state statutes have been set up in the history of state statutes, so that when I apply them to the immigration law, then I can know the nuances of those state statutes. So what we're going to do now is I'm going to go to a screen capture, and we're going to look at the actual grounds of inadmissibility that they're talking about on this Form I-485, and that really relates to the green card process. So I'm going to switch over to my screen capture now. So here is the USCIS homepage, and now is the time for me to give my disclaimer that I give in front of all these immigration tutorial videos, and that is that I cannot advise you on immigration law. All I'm doing here is I'm going through the immigration law and I'm explaining what the law means, trying to clarify some things about the law, and talking about what I've seen, what I've experienced working in immigration law for 12 years, actually 13 years now, and it's been 9 years as an attorney and 4 years as a paralegal. So I don't know what your facts are in your case and what you've done and what's going on. So when I give advice, I listen to my clients and I understand what's happening, and I will advise them on a plan of action or strategy. And so for you, I don't know what's going on, so it's impossible for me to advise you. For that reason, please do not rely on anything that I say here for your case. And with the issue of crimes and bad moral character, really you have to go and consult with an attorney. And my wish for you, my intention for you, is that as we go through this, you'll understand the framework by which the Immigration Service looks at your case, so that when you talk with an attorney, you're going to have some information already that's going to help you work with the attorney, get the information to him or her that they need to present your case to the Immigration Service, and that you'll be familiar with some of the language that they use. So we're here on the immigration website, and we're going to jump into laws and regulations. So click on that, laws, regulations, and guides. And on the left hand side here, you'll see Immigration and Nationality Act. Click on that. Immigration and Nationality Act, a little bit of history on it, and we're going to click on the hyperlink here that's going to bring us up into the Immigration and Nationality Act. So here's the law regarding immigration, and we go through Chapter 1, the selection system, Chapter 2, qualifications for admissions of aliens, travel control of citizens and aliens. And this is interesting for us here. You'll see Act 212, general classes of aliens ineligible to receive visas and ineligible for admission. Okay, admission, that's what we're talking about. Waivers of inadmissibility. There are waivers of inadmissibility. So when you are held to be inadmissible because of something you've done in the past, oftentimes there is a waiver that can clear out that problem and get you back on track for getting your green card. So for that reason, so important before you fill out your paperwork, before you may make an inaccurate statement on your paperwork, that you talk to an immigration attorney who knows about these types of waivers. And so let's see what else we got here. Admission of non-immigrants, all this stuff. There's a lot that goes through it. Issuance of entry documents. Here's another part that impacts us. Chapter 4, inspection, apprehension, examination, exclusion, and removal. Exclusion, right? That's doing something bad to get you kicked out of the country. So down here we can see there's a bunch of stuff. Apprehension and detention of aliens. General classes of deportable aliens, right there, the 237. Expedited removal of aliens convicted of committing aggravated felonies. That's right. So here's some more stuff. Initiation of removal proceedings. And removal proceedings are the immigration court. And then here's cancellation of removal. See, you can get your removal canceled, and that's a whole, it's actually a type of amnesty if you think about it. There are ways that you can forgive people who've even come in illegally, may have committed some crimes, and there are ways of getting them permanent residency, even though a lot of bad things they've done or they've had happen to them. So then we go through adjustment of status, and adjustment of status is what we're doing to get our green card. So this part of the law is also at play with what we're doing. Adjustment of status of non-immigrant to that of person admitted for permanent resident. Does that sound familiar after watching all those other videos? Definitely. And let's see what else we have. Removal of aliens who have fallen into distress. That removal is a big buzzword here. Alien crewmen, well, we're not too into that. Registration of aliens, we're not too into that. Well, actually, alien seeking entry registration, actually, that's part of the green card process too, but it doesn't really, you don't really need to know any of that stuff. General penalty provisions. Prevention of unauthorized landing of aliens. Bringing in aliens subject to exclusion on a health-related ground. Unlawful bringing of aliens in the United States. Bringing in and harboring certain aliens. Unlawful employment, unfair immigration-related employment practices. Penalties for document fraud. This one is actually right here, this 274C. Look at that. Let's go back to the... Here's our adjustment of status questionnaire, page 3 on here. We scroll down to this and we will see right there, look at this. Are you under a final order of civil penalty for violating section 274C of the Immigration and Nationality Act for use of fraudulent documents, or have you, by fraud or willful misrepresentation of a material fact, ever sought to procure or procured a visa, other documentation, entry in the United States, or any immigration benefit? Yes or no? So this question relates to this part of the law. And if we click on that, here comes the law, and we can look at it. Activities prohibited. It is unlawful for any person or entity knowingly to forge, counterfeit, alter, or falsely make any document for the purpose of satisfying a requirement of this act or to obtain a benefit under this act. The act is the immigration law. That's right. To use, attempt to use, possess, obtain, accept, or receive, or provide any forged, counterfeit, altered, or falsely made document in order to satisfy any requirement of this act or obtain a benefit under this act. So look at this, possessing, obtain, that's just buying and selling them, having them on your property. I mean, it's very broad. A lot of just handling a fraudulent document, accepting, receive, provide any forged, counterfeit, altered, or falsely made document in order to satisfy any requirement of this act. So that means if it says you need to have a work authorization card in order to work, that's what the act says. Well, I get a fake card to satisfy that part of the act. Okay, that's what it's talking about. To use or attempt to use or to provide or attempt to provide any document lawfully issued to or with respect to a person other than the possessor, including a deceased individual, for the purpose of satisfying a requirement of this act or obtaining a benefit. right to accept or receive or provide any document lawfully issued to or with respect to a person other than the possessor, including a deceased individual, for the purpose of complying with Section 274A(b) or obtaining a benefit under this Act. Here's where the attorneys get theirs: to prepare, file, or assist another in preparing or filing any application for benefits under this Act, or any document required under this Act, or any document submitted in connection with such application or document, with knowledge or in reckless disregard of the fact that such application or document was falsely made, or in whole or in part does not relate to the person on whose behalf it was or is being submitted. And to present before boarding a common carrier for the purpose of coming to the United States a document relates to the alien's eligibility to enter the United States, and B, to fail to present such document to an immigration officer upon arrival at the United States ports of entry. So this is deep document stuff. Here's an exception. Look at this. This section does not prohibit any lawfully authorized investigative, protective, or intelligence activity of a law enforcement agency of the United States, a state or subdivision of a state, or an intelligence agency of the United States, or any activity authorized under Chapter 224 of Title 18 U.S. Code. So there are exceptions then for law enforcement to use fake documents, to, you know, something right out of TV. And then here's the enforcement part of the law, and saying that they can, immigration officers and law judges can you know, act and put together hearings and different processes and procedures around, you know, penalizing people who do this kind of document fraud. And here's a little civil penalty here: not less than $250, not more than $2,000 for each document. And as we grow down and we see down here, look at this: waiver by Attorney General. The Attorney General may waive the penalties imposed by this section with respect to an alien who knowingly violates subsection A6 if the alien is granted asylum under Section 208 or withholding removal under Section 241b3. So people who come in a lot of times on asylum, they have to use fake documents even to get out of the country, and so they allow for a waiver. Again, yes, was it bad for them to use a fake you know, birth certificate to get out of the country? Yes, but it says right here, waiver by the Attorney General. Okay, so this is what I want to show you. In the law, they can set up some severe penalties, but at the same time, they include a waiver for people of certain classes. So this is why you need to understand the laws and get in with people who know the law, because it's all about finding these waivers. It's all about finding the exceptions to the law, and you need to work with someone who is definitely, you know, knowledgeable about that. So let's go back then to the 212, because this is really the main part where where most of these laws are that we're going to be talking about and getting your green card that you need to know about. So, classes of aliens ineligible for visas or admission, except as otherwise provided in this Act. Aliens who are inadmissible under the following paragraphs are ineligible to receive visas and ineligible to be admitted to the United States. So remember, when we're filing this, the package of documents, we're filing an I-130. That's the petition for the alien relative, and that can give us, get us the visa. That's our visa application. And the other part of it is the I-485. That's the application to adjust status to that of a permanent resident. So it's the two of those, and you're seeing ineligible to receive visas, so you can get knocked out even if you're just filing the I-130, or ineligible to be admitted in the United States, knock you out if you're trying to filing the I-485. Okay, so it starts with the health-related ground here, and our focus is going to be with the criminal activities and the bad moral character. And health-related grounds, for the most part, it talks about here, any alien who is determined to have a communicable disease of public health significance, which shall include infection with the etiologic agent for acquired immunity deficiency syndrome, so that's AIDS. And then there's other mumps, measles, rubella, different types of communicable diseases. I mean, that's really the health-related ground, is what we all think of. But here's one here. Listen to this. Who is determined, in accordance with regulations prescribed by the Secretary of Health and Human Services in consultation with the Attorney General, to have a physical or mental disorder and behavior associated with the disorder that may pose or has posed a threat to the property, safety, or welfare of the alien or others, or to have had a physical or mental disorder and a history of behavior associated with the disorder which behavior has posed a threat to the property, safety, or welfare of the alien or others, and which behavior is likely to recur or lead to other harmful behavior, or who is determined, in accordance with regulations prescribed by the Secretary of Health and Human Services, to be a drug abuser or addict, is inadmissible. Okay, a drug abuser or addict. Now this is what we're talking about with bad moral character. A conviction for drunk driving can raise a health-related ground of inadmissibility, because, check it out, they say you have a mental disorder, alcoholism, and a behavior associated with the disorder, drunk driving, that may pose or has posed a threat to the property, safety. You're driving around drunk, you're crashing into cars, that is a big deal. So they can knock you out, even if, you got a wet reckless or something like that, and it doesn't rise up to be a criminal situation. It can still qualify under a health-related ground if they felt that you were an alcohol abuser and driving drunk. Especially, one of the things they look to is the widespread knowledge around drunk driving and how everyone knows how bad it is, and they think it's so likely and so obvious that people know now that driving drunk is a serious threat. So they're done. They're basically, more and more are getting people disqualified and finding them to be inadmissible because they are a habitual drunkard or a drug abuser, an alcohol abuser. And then who is determined to be a drug abuser or addict is inadmissible. So some of the minor convictions for marijuana use, they might say, well, when's the last time you used marijuana? Oh, I used to use it a lot, but I don't use it anymore. Watch out, they're going to say, well, you were a drug abuser then, and was it within 5 years, within 10 years, different. If it was recent, then you could come up with this. But look again, waiver authorized for provision authoring waiver of certain clauses of subsection A, see subsection G, small g. So let's just go ahead and let's go forward to small g. We're going to see a bunch of these grounds of inadmissibility. Small g is going to be down here. We're scrolling down, scrolling down, scrolling. And let's see, we've got we got 10. I just reached the bottom. What happened? Did I miss it? Nine. Oh, I see. Next page. Next document. 212B. Here's H. So I've gone forward, and we're going to G. You have G, H. We got to go back one. A, B, C, no. There's E, F, G. Here we go. I found it. Woohoo! G. The Attorney General may waive the application of subsection A1A1 in the case of any alien who is the spouse or unmarried son or daughter or the minor unmarried lawfully adopted child of a United States citizen or of an alien lawfully admitted for permanent residence or of an alien who has been issued an immigrant visa, has this son or daughter who is a U.S. citizen, an alien lawfully admitted for permanent resident, or an alien who has been issued an immigrant visa, or is a VAWA self-petitioner, Violence Against Women Act. In accordance with such terms, conditions, and controls, if any, including the giving of bond as the Attorney General in the discretion of the Attorney General after consultation with the Secretary of Health and Human Services, may by regulation prescribe. Okay, so again, if you are the spouse or an unmarried son or daughter, or the minor unlawfully adopted child, or has a son or daughter who is a United States citizen. So if you are a grown-up son or daughter and you're married, then you're not going to be able to get this waiver for that the health-related ground of inadmissibility. So this law then is, does have a waiver, and waiver authorized. There it is. See subsection G. So there is a waiver. So that's how the waiver works. So you've got the law, and then you have the waiver, and this is where it is, and that's why I'm walking you through this law. So if you've got a problem, you can go to an attorney and say, well, I've got this thing, but what is there a waiver available? And it's good to know that for sure. And so let's go to the next one. Here we go. Criminal and related grounds. Conviction of certain crimes in general, except as provided in Clause 2, which is down here. Any alien convicted of or who admits having committed or who admits committing acts which constitute the essential elements of 1. A crime involving moral turpitude, other than a purely political offense or an attempt or conspiracy to commit such a crime. Or, so that's an interesting thing, political offense, disturbing the peace, unlawful assembly. Okay, we're not counting those. Or a violation of or conspiracy or attempt to violate any law or regulation of a state, the United States, or a foreign country relating to a controlled substance as defined in Section 102 of the Controlled Substances Act, 21 U.S.C. 802, is inadmissible. So this one here, the conviction of certain crimes, A, is the crime of moral turpitude one. And where that pops up, where these pop up in the I-485 form, then is right up at the top here. Have you ever, in or outside the United States, knowingly committed any crime of moral turpitude or drug-related offense for which you have not been arrested? Okay, great. So, back to the law. We see that exception. Clause I-1 shall not apply to an alien who committed only one crime if, okay, we have an exception now. The crime was committed when the alien was under 18 years of age, and the crime was committed and the alien released from any confinement to a prison or correctional institution imposed for the crime more than 5 years before the date of application for a visa or other documentation and the date of application for admission to the United States. So If you're young and it happened a while ago, then it may not apply to you. All right. Or the maximum penalty possible for the crime for which the alien was convicted, or which the alien admits having committed, or of which the acts that the alien admits having committed constituted the essential elements, did not exceed imprisonment for 1 year, and if the alien was convicted of such a crime, the alien was not sentenced to a term of imprisonment in excess of 6 months, regardless of the extent to which the sentence was ultimately executed. So, petty drug offenses then, right, conviction of certain crimes. And you've got the shall not apply to an alien committed only one crime if, and look at this. Or which the alien admits having committed, or of which the acts that the alien admits having committed constituted the essential elements. So if they ask you, have you ever tried cocaine, right, and you've never been convicted of it, but you admit to having done it, then you are considered to be convicted of certain crimes. It is the same as if you were convicted of certain crimes. So it says, or who admits committing acts which constitute the essential elements. So you have to be very careful when telling your stories about things. Now, if you're under 18 years of age, you want to make it really, really clear. Look, I did it, but I was under 18. So, and it was just the one crime. You know, your attorney is going to want to make sure that you talk about that. But if if the situation is that you were over 18, or there was more than one crime, and you are not covered by this exception, then you're going to have to take care of that and find the waiver for it. Multiple criminal convictions. Any alien convicted of 2 or more offenses other than purely political offenses, regardless of whether the conviction was in a single trial or whether the offenses arose from a single scheme of misconduct, and regardless of whether the offenses involved moral turpitude, for which the aggregate sentence to confinement were 5 years or more, is inadmissible. So here's this 2 conviction ground as well of inadmissibility. So again, I mean, lying about this stuff and not putting it on the application, again, it's just can't go there. You've got to be able to meet with an attorney, talk about it, and figure it out. Now, there's some of the tricks that come up around this that attorneys can do are going back to a conviction and having it vacated because you were not advised of the immigration consequences of a crime. Now, the reason why it's so important to know about this is because immigration law is very, very complicated, and most criminal attorneys, when they are talking with you in your arraignment, especially if it's like a public defender, they may not even talk to you other than say, is this your name? You know, we're going to plead you guilty because we don't want you to go to jail for 25 years, right? Oh, yeah, right. You're not getting any information about waivers, about the situation with your immigration. And, you know, oftentimes many people would much rather plea bargain in a way that maybe they go in jail longer, but they get a reduction, or they get to choose a different sentence and will choose to be convicted of a crime that does not have a significant immigration impact. So if you're not given that type of advice in your plea bargaining, you're not really given your due process. You're not really given full representation in the matter. So if you feel that you've made an error, and you're just now learning about this immigration law stuff, and you're just now understanding how what you pled to can really mess up your whole immigration case, you know, this is one way, this is one tool that we use to get you out of it. Because by going back and having the sentence vacated, meaning that the sentence will be taken away as if it was never actually imposed upon you, everything is wiped clean, then you no longer have a crime of moral turpitude, or you know, a a controlled substance, a drug offense on your record. It's a very, very, very powerful tool that attorneys can use, and it's different from, you know, an expungement, because expungements are saying, okay, yeah, you were convicted of a crime, but you know, you've been such a great person since then, we're going to go ahead and expunge the record. Well, to the Immigration Service, that means nothing. Who cares? We're the federal government. We give waivers, and we deport people who are inadmissible. That's our job. You can't give, you know, your expungement means nothing. And that's, you know, that's pretty much the perspective of the Immigration Service. And however, when a state court goes, you know what, we blew it. We did not apply the Constitution properly. You did not have proper due process. There was a violation of your fundamental constitutional rights. And we have the authority to interpret the Constitution. We have the authority to interpret federal law as it relates through the Constitution in every court in every county of the United States. So we know that this is bad. Excuse me. So for that reason, we're going to vacate this conviction. So now are there hurdles to doing this? Yes. Do judges like to go back, reopen cases, and set people free? No, absolutely not. I mean, they look at the floodgates thinking, oh my God, what if every immigrant came back now and asked for that? So, you know, it's very, it's difficult. It's definitely difficult to go back. However, I mean, Norton Tooby has really coached me, and I've gone to his presentations, talked to him, and I have used his presentations, his skills to get courts to do the right thing. And it has to be, you know, it has to be done in a way that is very professional, and you know, it has to be done in a way that's also very comprehensive. You have to do it right, and if you do it right, it can be done. It's done all the time. So that's very, very important for you to know those aspects of the criminal grounds. So let's see. We went through that. Okay, here's the next one. Controlled substance traffickers. Man, this is a tough one. Any alien who the consular officer or the attorney general knows or has reason to believe is or has been an illicit trafficker in any controlled substance or in any listed chemical as defined under 102 of Controlled Substance Acts 21 U.S. Code 802, there's that thing again, or is or has been a knowing aider, abettor, assister, conspirator, or colluder, basically a helper, with others in the illicit trafficking in any such controlled or listed substance or criminal, or endeavored to do so, or is the spouse, son, or daughter of an alien inadmissible under Clause I, has, within the previous 5 years, obtained any financial or other benefit from the illicit activity of that alien, and knew or reasonably should have known that the financial or other benefit was the product of such illicit activity, is inadmissible. Yeah, the controlled truff, you know, look at that. And where's the part about the waiver? Where's the exception? You know, doesn't look like it's there. Yeah, some of these things, they, you know, they don't play. You know, if you go down that road and they've got proof that that's it, that's what happened, then you've got a serious problem. Prostitution and commercialized vice. An alien who is coming to the United States solely, principally, or incidentally to engage in prostitution, or has engaged in prostitution within 10 years of the date of a pre-application for a visa, admission, or adjustment of status, directly or indirectly procures or attempts to procure. So it's the person who's giving the prostitution, also one who purchases the prostitute, within 10 years, or persons for the purposes of prostitution, or receives, or within such 10-year period, received in whole or part the proceeds of prostitution, or is coming to the United States to engage in any other unlawful commercialized vice, whether or not related to prostitution, is inadmissible. Right. So that one is really, I don't know, it's controversial, I think, just because you have a whole state of Nevada that allows for prostitution, so coming to the United States to engage in prostitution, hey, I'm flying to Las Vegas to visit the Mustang Ranch, sorry, you're inadmissible. Well, okay, so, but that's the way it goes. Waiver authorized. For provision authorizing waiver of certain subparagraphs in this paragraph, see subsection H. Okay, we looked at G before, so let's look at H now. 212B. Oh, I think this was that second click over. Here it is, 212H. The Attorney General may, in his discretion, waive the application of subparagraphs A, I, 1, B, D, and E of subsection A2 and subsection AI2 of subsection insofar as it relates to a single offense of simple possession of 30 grams or less of marijuana, and if the case of any immigrant is established to satisfaction of the Attorney General that the alien is inadmissible only under paragraph D1 or D2 of such subsection, or the activities for which the alien is inadmissible occurred more than 15 years before the date of the alien's application for visa, admission, or adjustment of status. The admission to the United States of such alien will not be contrary to the national welfare, safety, or security of the United States, and the alien has been rehabilitated. So you're starting to understand what you're going to need to show in these waivers. In the case of an immigrant who is a spouse, parent, son, or daughter of a citizen of the United States, or an alien lawfully admitted for permanent residence, if it is established to satisfaction of the Attorney General that the alien's denial of admission would result in extreme hardship to the U.S. citizen or lawfully resident spouse, parent, son, or daughter of such alien, or the alien is a VAWA self-petitioner, okay, different categories, and the Attorney General, in his discretion, pursuant to such terms, conditions, and procedures as he may by regulations prescribe, has consented to the aliens applying or reapplying for a visa or admission to the United States or adjustment of status. So this is the waiver part of this, and this is what they call a 212H waiver. And there's some limitations on it. Here's another one. The Attorney General, in his discretion and pursuant to such terms, conditions, and procedures as he may by regulations prescribe, has consented to the aliens applying or reapplying for a visa for admission in the United States or adjustment of status. No waiver shall be provided under this subsection in the case of an alien who has been convicted of or has admitted committing acts that constitute murder, or criminal acts involving torture, or an attempt or conspiracy to commit murder or a criminal act involving torture. No waiver shall be granted under this subsection in the case of an alien who has previously been admitted to the United States as an alien lawfully admitted for permanent residence if either since the date of such admission the alien has been convicted of an aggravated felony or the alien has not lawfully resided continuously in the United States for a period of not less than 7 years immediately preceding the date of initiation of proceedings to remove the alien from the United States. No court shall have jurisdiction to review a decision by the Attorney General to grant or deny a waiver under this subsection. So, it's interesting about the torture thing, precluding waivers for torture. It really is abhorrent, and it's against our way of law. Our whole law, is so biased against torture, and yet, the United States has, been torturing people, and it's really, I hate that about the current power structure right now, that it's going against our laws. And so this is the waivers, and it goes into the way it's set up. You can see subparagraphs A, I, 1, B, D, and E of A2. So let's go back then to subsection 2, A, I, here's B, didn't see C, did you? No. D, B, and D, right? C, where's the C? A, B, there's no C there. Okay? Some of this stuff is just way too bad. There's no waiver. Right? Controlled substance traffickers. D, E, certain aliens involved in serious criminal activity have asserted immunity from prosecution. Okay. Here's another one. Foreign government officials who have committed particularly severe violations of religious freedom. Significant traffickers in persons. Okay. Money laundering. Who a consular officer or attorney general knows or has reason to believe has engaged in engaging or seeks in the United States to engage in offense described in section 1956 or 57 of Title 18 U.S. Code. Security and related grounds. Here we get into terrorist stuff. Terrorist activities. Member of a terrorist organization, and terrorist activity defined. Assassination. Terrorist organization defined. There's another one. Participants in Nazi persecution, genocide, or the commission of any act of torture or extrajudicial killing. So we give no safe harbor to those people. Note again, commission of acts of torture or extrajudicial killings. Association with terrorist organizations. So yeah. Oh, look at this, public charge. Here's another basis right here. The public charge. Now this is not really a crime or a bad moral character, but it is, it is one of those aspects of the form here, right? Right here. Have you received public assistance in the United States from any source, including the U.S. government or any state, county, or municipality? This one here, here's where it pops up in the law. Public charge. Right. Then there's a labor certification basis of inadmissibility, which is really relates to the business side of it, not so much the family side. And going, here's another one. Illegal entrants and immigration violators. Oh, now this is a biggie. Alien present without admission or parole. Now, the thing about this, illegal entrants and immigration violators, is that it's not really criminal activity in the way that we think about it, where you're going to go to criminal court and get convicted of a criminal conviction. A lot of this stuff is people who just enter illegally and cross the border without being inspected. So it's a different type of problem that comes up. And so you'll see here, aliens present without admission or parole, and an alien present in the United States without being admitted or paroled, or who arrives in the United States at any time or place other than is designated by the Attorney General, is inadmissible. Now we have a different tutorial that deals with the illegal entry. So we go all into that, and but just to touch on it here, there's the misrepresentation basis, falsely claiming citizenship, and waiver authorized for provision authorizing a waiver of clause I, see subsection L. Okay, misrepresentation I, false claim to, doesn't look like there's a waiver for that, so watch out, false claim citizenship. You know, you'll be, if you're going to get a green card and you falsely claimed citizenship, you got a problem there. Real problem. Then you got stowaways. You got your smugglers in there. And draft evaders. Aliens previously removed. Yeah. Aliens unlawfully present. Here's the unlawful presence that we've been talking so much about, and we will talk more about that in the other video tutorial. And then the rest of the law here rolls through the process here for dealing with that. So this then is, again, here's the I-485 form, and here's all the terrorist stuff, and the Communist Totalitarian Party. Here's the Nazi stuff, more genocide and ethnic, religious oppression. Here's the previous deportation stuff. We already went through that one. Draft, remember that. The J immigrant, I think that's further back in the statute. And withholding custody of U.S. citizen, there's a special part of the law around that. Do you plan to practice polygamy in the United States? Where was the polygamy one? It's in there somewhere. I don't think I've ever read that one. But so in addition to the grounds of inadmissibility, we have this grounds of excludability, general classes of deportable aliens. Let's look at this. 237. Classes of deportable aliens. Any alien, including alien crewman, in and admitted to the United States shall, upon the order of the Attorney General, be removed if the alien is within one or more of the following classes of deportable aliens. So again, a person who's coming in to get adjustment of status, they've been admitted already once. So at this point, they are they're deportable. And if they've done something like this, there's a whole different, they can just be put right into immigration proceedings. And this could happen before they go before the immigration interview. Inadmissible at time of entry or of adjustment of status or violate status. Okay, so A, inadmissible aliens. Any alien at the time of entry or adjustment of status is within one or more of the classes of aliens inadmissible by the law existing at such time as deportable. Well, that relates back to the whole, it incorporates all the grounds of inadmissibility. Present violation of law. Any alien who is present in the United States in violation of this act or any other law of the United States, or whose non-immigrant visa or other documentation authorizing admission in the United States as a non-immigrant has been revoked under Section 221 is deportable. Okay. Violated non-immigrant status or condition of entry. Non-immigrant status violators. Any alien who was admitted as a non-immigrant and who has failed to maintain the non-immigrant status in which the alien was admitted or to which it was changed under Section 248 or to comply with the conditions of any such status is deportable. Violators of conditions of entry. Any alien whom the Secretary of Health and Human Services certifies has failed to comply with the terms, conditions, and controls that were imposed under Section 212G is deportable. So with regards to the first one here, okay, I have seen people put into deportation proceedings who fail to file a change of address form, and this is what they are charged with. Their non-immigrant status. The non-immigrant status says you're going to file a change of address whenever you move in your non-immigrant status. They can deport you for that. And then the Secretary of Health and Human Services, conditions and controls, they may say you have to, get shots. They may say you have to refrain from drinking, or those types of conditions of entry based on your past stuff. So you could be deportable as well if violate those conditions. Termination of conditional permanent residence. Any alien with permanent resident status on a conditional basis under Section 216 relating to conditional permanent resident status for certain alien spouses and sons or daughters, or under Section 216A relating to conditional permanent resident status for certain alien entrepreneurs, spouses, and children, who has had such status terminated under such respective section is deportable. So, you get married, U.S. citizen, you get a 2-year green card, and you're supposed to remove those conditions and get a 10-year green card after that. Well, if you forget to do that, for some reason, you haven't done it, then you are deportable at that point too. And here's the exception clause. Shall not apply in the cases described in Section 216C4 relating to certain hardship waivers. So yes, there are waivers of this available, and it comes down to, if you're divorced or if you were subjected to extreme cruelty, then they can choose to not apply this to you and give you a waiver. Smuggling. This is an interesting one here because this ground of deportability has actually got a waiver authorized in it here. In general, any alien who, prior to the date of entry, at any time of any entry, or within 5 years of the date of any entry, knowingly has encouraged, induced, assisted, abetted, or aided any other alien to enter or to try to enter the United States in violation of law is deportable. So you go down with the person you're trying to help. But check this out. Special rule in the case of family reunification. Clause I, that first one, shall not apply in the case of an alien who is an eligible immigrant, as defined in Section 301B1 of the Immigration Act of 90, was physically present in the United States on May 5th, 1988, and is seeking admission as an immediate relative or under Section 203A2, or benefits under Section 301A of the Immigration Act of 90 if the alien before May 5, 1988 has encouraged, induced, assisted, abetted, or aided only the alien spouse, parent, son, or daughter, and no other individual to enter the United States in violation of law. So the eligible immigrant there is a category, and you can check it under 301B1 of IMACT 90. Waiver authorized. The Attorney General may, in his discretion for humanitarian purposes, to assure family unity, or when it is otherwise in the public interest, waive application of Clause I in the case of any alien lawfully admitted for permanent residence You got to be a green card holder. If the alien has encouraged, induced, assisted, abetted, or aided only an individual who at the time of the offense was the alien's spouse, parent, son or daughter, and no other individual to enter the United States in violation of law. So if it's just bringing in your family members, there is a waiver available for them. Here's another one here. Marriage fraud. This is a ground of deportability. An alien shall be considered to be deportable as having procured a visa or other documentation by fraud within the meaning of Section 212 ACI, and to be in the United States in violation of this Act. If the alien obtains any admission into the United States with an immigrant visa or other documentation procured on the basis of a marriage entered into less than 2 years prior to such entry of the alien, and which, within 2 years subsequent to any admission of the alien in the United States, shall be judicially annulled or terminated unless the alien establishes to the satisfaction of the Attorney General that such marriage was not contracted for the purpose of evading any provision of the immigration laws. Okay. Or it appears to the satisfaction of the Attorney General that the alien has failed or refused to fulfill the alien's marital agreement, which in the opinion of the Attorney General was made for the purpose of procuring the alien's admission as an immigrant. So if they fail or refuse, you can definitely, that's, the marriage fraud can be devastating. And this is not even including the criminal charges and the fines. Then H, you got this here. We are in 237H waiver. Waiver authorized for certain misrepresentations. The provisions of this paragraph relating to removal of aliens within the United States on the ground that they were inadmissible at the time of admission as aliens described in Section 212A6CI, whether willful or innocent, may, in the discretion of the Attorney General, be waived for any alien other than one described by 4D, who is the spouse, parent, son or daughter of a citizen of the United States or of an alien lawfully admitted to the United States for permanent residence, and was in possession of an immigrant visa or equivalent document and was otherwise admissible to the United States at the time of such admission, except for those grounds of inadmissibility specified under paragraphs 5A and 7A of Section 212A, which were a direct result of that fraud or misrepresentation, or if they're involved with self-petitioner. A waiver for removal for fraud or misrepresentation granted under this subparagraph shall also operate to waive removal based on the grounds of inadmissibility directly resulting from such fraud or misrepresentation. So we're talking about inadmissibility, and they're allowing the waivers under the deportability charge to also cure the inadmissibility charge. Criminal offenses. Here's our crime of moral turpitude, so we've kind of been in that one already. Multiple criminal convictions. Any alien who at any time after admission is convicted of 2 or more crimes involving moral turpitude not arising out of a single scheme of criminal misconduct, regardless of whether confined therefor, and regardless of whether the convictions were in a single trial, is deportable. So that's the 2 strikes and you're out right there. Aggravated felony. Any alien is convicted of an aggravated felony at any time after admission is deportable. And there's nowadays there's no waivers for that aggravated felony. High-speed flight. And what is an aggravated felony? Well, there's a list of aggravated felonies in the statute, and those crimes are very, very serious. There's no waiver available for them, and it's basically the kiss of death if you are convicted of an aggravated felony. High-speed flight, okay, they get a deportability on that. Failure to register as a sex offender, okay. Section 1, 2, 3, and 4 shall not apply in the case of an alien with respect to criminal conviction of the alien subsequent to the criminal conviction is granted full and unconditional pardon by the President of the United States or by the Governor of any of the several states. So, aggravated felony can get a governor's pardon, and that's how you'll get out of an aggravated felony one. But that's different from a waiver, boy. Controlled substances, okay, you got the controlled substance conviction. Drug abusers and addicts, okay, deportability there. Firearm offenses, okay, purchasing, selling, offering for sale, firearms. Miscellaneous crimes. Any alien who at any time has been convicted, the judgment on such conviction becoming final of, or has been so convicted of a conspiracy or attempt to violate any offense under Chapter 37. We got espionage, sabotage, treason, and sedition. And then here's another one, 871 or 960 of U.S. Code. Military Selective Service Act violation, or the Trading with the Enemy Act. A violation of Section 215 or 278 of this Act is deportable. Look at this one. Crimes of domestic violence, stalking, or violation of protection order. Crimes against children. So, domestic violence crimes, protection orders are deportable. Failure to register and falsification of documents. So, those are also deportable ones. Here's document fraud, 274C. We looked at that before, but there's a waiver authorized. Here's false claim for citizenship. And security and related grounds here are all the terrorist activities, unlawful voters, waivers for victims of domestic violence. So this is interesting. The Attorney General is not limited by the criminal court record and may waive the application of paragraph E2I with respect to crimes of domestic violence and crimes of stalking. And 2, in the case of an alien who has been battered or subjected to extreme cruelty and who is not and was not the primary perpetrator of violence in the relationship. So if you defend yourself and you get busted and you can prove that, then you won't necessarily be charged as a domestic violence ground of deportability. And there it is, self-defense. And here's the credible evidence to be considered. So those are the other aspects of criminal convictions that can really be a problem and can get you deported. So when you go to your adjustment of status, they say, why are we going to adjust your status? You're deportable. So we want to find the aggravated felony charges. So the rules on aggravated felony can be found here at INA 101A 43. And here it says the term aggravated felony means murder, rape, or sexual abuse of a minor, illicit trafficking and controlled substance, including a drug trafficking crime. So we've seen controlled substances all over the place here. Illicit trafficking in firearms or destructive devices or explosive materials. Firearms. An offense described in Section 1956 relating to laundering of monetary instruments, or in 1957 of that title relating to engaging in monetary transactions and property derived from specific unlawful activity if the amount of the funds exceeded $10,000. So there's a money laundering offense here that can also be considered an aggravated felony. And then here's relating to explosive material offenses, more firearm offenses, and more firearm offenses here. Here's one, a crime of violence as defined in Section 16 of Title 18 U.S. Code, for which the term of imprisonment is at least 1 year. That'll get you out of here. A theft offense including receipt of stolen property or burglary offense, which the term of imprisonment is at least 1 year. An offense described relating to demand for or receipt of ransom. There's 2251 relating to child pornography. Here's the one with the RICO, racketeer influenced corrupt organizations, or offense described gambling offenses, for which a sentence of 1 year imprisonment or more may be imposed. Offenses that relates to owning, controlling, managing, or supervising of a prostitution business. Transportation for the purpose of prostitution if committed for commercial advantage, or peonage, slavery, involuntary servitude, and trafficking in persons. Then you have security issues here. Transmitting national defense information, relating disclosure of classified information, treason, sabotage, identity of undercover intelligence agents. And then look at this one. An offense that involves fraud or deceit in which the loss of the victim exceeds $10,000. So that could even be an offense. That could be a civil offense there. Is described in 7201 of the Internal Revenue Code, tax evasion, in which the revenue loss to the government exceeds $10,000. And then we have here alien smuggling. But then look, you got except in the case of a first offense for which the alien has affirmatively shown that the alien committed the offense for the purpose of assisting, abetting, or aiding only the alien's spouse, child, or parent. So that is definitely carved out there for the immigrants to be able to not be too harshly punished for bringing in their own family members. And then here's which is a passport forging and counterfeiting. Except in the case of a first offense for the alien is firmly shown that the alien committed the offense for the purposes of assisting the spouse, child, or parent. An offense relating to failure to appear by a defendant for service of sentence, and the underlying offense is punishable by imprisonment for a term of 5 years or more. So there's people who don't go would jump bail. Commercial bribery, counterfeiting, forgery, trafficking vehicles, the identification numbers of which have been altered, for which the term of imprisonment is at least 1 year. Offense relating to obstruction of justice, perjury, bribery of a witness, failure to appear for a court pursuant to a court order to answer to or dispose of a charge of a felony for which a sentence of 2 years imprisonment more may be imposed. Yeah, that's failure to appear can be aggravated felonies. An attempt or a conspiracy to commit any of those, just an attempt to do it or a conspiracy to do it, is also just like you did it. And those are the aggravated felonies. That is a brief overview of the situation with regard to the law and the main bases for not being allowed into the United States based on past criminal activity and bad moral character. We also talked about some of the ways that we can vacate sentences and get relief, and we've showed you some of the situations where the waivers come up. Now, one final part of this is that if you are filing for a green card and you have a criminal problem and they deny your application because they found you to be inadmissible, it's very much possible that you'll have one more bite at the apple in immigration court. An immigration court then is important to know about, and I've got the website here for immigration court. Here's our Memphis, Tennessee immigration court, but the main immigration court listing is here at eoirjustice.gov, Department of Justice, United States Department of Justice, Executive Office for Immigration Review. And the immigration court will process what they call removal proceedings. It used to be called deportation. But if you're denied adjustment of status, you might get an opportunity to go before a judge and present your case again. And there are different standards of review, and there are different programs available in immigration court. So that might also be a viable way for you in a long-term strategy then, because remember we saw cancellation of removal, and there's adjustment of status in immigration court. Just because someone's inadmissible and found to be inadmissible in an adjustment of status application and on an adjustment of status interview, you still have a shot many times at immigration court. And by talking to an immigration attorney, you'll start to realize what's available to you in immigration court. Now, they just came up with a new manual, and they've got the new immigration procedures manual here, which has a lot of immigration information on it. Man, this thing is great. And one thing about the glossary here, I walked through this glossary. There is so much information here. Great stuff on terms that they use. And if you're going through a process with your immigration lawyer, it might be very helpful to you to look through this glossary and at least bounce some ideas off, or just get clear, understand what you're talking about, know the words, know the terms. And because when you jump over into immigration court, then it's a different set of rules and it's a different standard of review. So there's actually appeals of a lot of the different rulings in immigration court. So it's very, very helpful to know the big picture of your case, and immigration court's an important part of that. So this concludes our tutorial on crimes and bad moral character. And again, I really wish you the most ease and greatest success in your immigration case so that you can get the adjustment of status and get that green card that you so richly deserve.